A retainer is no different than a contract between you and Bell Canada or you and the seller of the house that you are buying. If you don't have a contract, you don't have consensus ad idem, you don't have a meeting of the minds, you don't have reasonable expectations of one another. And we, in 2025, live in an era where the Law Society of Ontario would wonder what kind of lawyer you are if you don't have a retainer agreement. And that retainer agreement does not have to be pro forma, the one that you download. After you have dealt with different scenarios, depending on the area of law that you do, the nature of work that you do, how you do it, and so forth, you can put in terms in there that express to the client things that you do and things that you don't do. So for example, I'll use a basic one. There's still a lot of lawyers that collect a retainer when they open up the account, and then when they bill against the existing retainer. We don't do that at my firm. That retainer sits there until the very end. And every time we bill a client, generally speaking, between the $2,000 to $3,000 mark, while we have $5,000 in the retainer in the trust account. And that way, the client is conditioned at low-level bills to know what things cost, so that when they send us back and forth 30 or 40 emails in the course of a week, they realize very quickly what that costs. And there's conditioning involved in that exercise. And that's right in the retainer agreement. Another one is some clients think that because we live in an era where all of us have iPhones, that means that they can communicate with us 24/7, weekends and holidays. Well, retainer agreements, no different than a sign on a store, says the open hours. And when a client says, I sent you an email on Saturday, I didn't hear back from you until Monday, you can very honestly say, oh, I'm so sorry you forgot, but this is contained in paragraph such and such of the retainer agreement. And so another thing is some clients will say, well, I want a copy of my whole file. Well, in the retainer agreement, it could say, throughout the course of the retainer, everything that I get or send out, you get a copy of it contemporaneously, so that at the end of your case, you've got everything and there will never be a need to package it all up and send it to you or to another lawyer in the future. So whatever situation might arise is covered in the retainer agreement. And generally speaking, you cannot sign another retainer agreement during the retainer. So you actually have to think in advance, what am I getting myself into? And for those of you that do not want to find themselves locked into not only a retainer agreement, but being solicitor of record, you have to think about, is this going to be a full service retainer agreement or a limited scope, or also called unbundled legal service, in which case you are narrowing the scope of the expectations of the client and of the court and of opposing counsel of you. And although some judges may not like the notion of agent work, that's a tool that the Law Society has approved and that you as a lawyer are permitted to execute with respect to clients. And if you've got a client that you're not so sure about, do I want to get on the record? Will this client be able to afford having me on for the totality of the case? Then that's a conversation that you should have with a client to determine the limitations on the nature of the retainer.